Welcome back to Primetime News.
And a special welcome to our viewers on OneSpotMedia.com.
Up first this evening, the Holness administration will have to decide what next after today's court ruling, which struck down the law under which the national ID system is to be implemented.
The Constitutional Court ruled that the National Identification and Registration Act, the law under which a national ID is to be issued, is null and void, unconstitutional, and having no legal effect.
Now, the government in response has so far sent out a terse statement only saying, quote, it is reviewing the judgment, end quote, and will, quote, provide a fulsome response, end quote. Now, efforts to get the Prime Minister's response to the ruling while on assignment in Trelawney and St. James today failed, with his communication staff barring attempts to do so by our correspondents.
However, we have reactions from the opposition, lawyers and Jamaicans for justice to the ruling in this newscast and a flashback on how we got here. But first, here's TVJ's Andrea Chisholm.
The Chief Justice summarizing the unanimous decision of the court.
We are of the view that the National Identification and Registration Act is to be declared null and void and of no legal effect.
Through NIDS, Jamaicans had no choice but to turn over personal information to the state so they could get a unique number or card to do business.
We have found that the mandatory requirement deprived the person of choice. That is, they were not free to decide whether to participate in the scheme or not. It was not a voluntary scheme. In addition to that, there was the compulsory, not just the compulsory nature, but also the fact that it was backed up by the risk of criminal prosecution.
Information on the NIDS was not limited to standard personal details such as names and addresses. Biometric data, including blood type, vein pattern, retina or iris scan, were also included.
The literature tells us that you can glean information about a person's state of health from an iris scan. You can determine almost what illness they're suffering from, what's the likely medication they're on, and other things that are very personal and private to them. So hence the question of informational privacy loomed large in our considerations.
Chief Justice Sykes, Justice David Batts and Justice Lisa Palmer Hamilton also indicated that the unique identification number would work across different databases of the government.
And so enabling now the state to pull together vast amounts of information about the citizen and in effect put itself in a position to derive new information and new knowledge by this combination of information now. And that we felt was a violation of the privacy rights.
Plus, the law did not have adequate protection to store and keep data safe. And since the Charter of Rights states that Parliament shall pass no law which infringes the rights of citizens, the National Identification and Registration Act was struck down and declared unconstitutional. In the meantime, there was reference to the Attorney General's suggestion that the NIDS law was urgent. The judges disagreed, saying the law is not in effect and no one knows when it will be. Chief Justice Sykes writes, no one has suggested that the sky has fallen in or will fall in if the law is not immediately enforced. That's because the society is still functioning even though the law is not operational. Andrea Chisholm, TVJ News.